is about a book. It is about a book which tries to be both a guidebook and a map. And today I will concentrate on the map aspect of the book, leaving the guidebook to your reading. So the Sharia is literally the mundane path that leads to God. This path, as for many religions, englobes a normative dimension, that is, a set of prescriptions and prohibitions. The Sharia is thus a law with a capital L, since it is of a divine essence. This being said, one has still to explore the sources from which the law derives, the hierarchy, their interpretations, how scholars and believers got hold of it, and the many forms it can take in various contexts. Among the many possible understandings of the term Sharia, there are two which, although antithetical, respond to each other as in a game of deforming mirrors. One makes of the Sharia a virtuous abstraction, a model of behavior, and an intangible norm for the believer. The other considers the Sharia as the incarnation of backward Islam, the holder of values intrinsically opposed to modern civilization, and makes it a scarecrow against anything presented as Islamic. Both perspectives have in common to reify the Sharia, to make of the Sharia something in itself, an essence, with this paradoxical consequence that it is not so much the sources on which these antagonistic conceptions are drawing which differ than the value that is attributed to them. In other words, these two conceptions are the two faces of the same coin, solidary and inseparable, although they are posited to the antipodes of one another. This is always the same trick, I forgot to move to the next slide. A dispatch of the French television dated of December the 6th, 2016, can serve us as a starting point. Here is an excerpt. The terrorist group Islamic State, ousted from its Libyan stronghold of Sirte last Monday by the forces of the National Union government, had established a daily organization regulated by the Sharia. During more than 1.5 years, in this coastal city, ultra-radical Islamists had created the embryo of an Islamic State. With the help of tribunals, prisons, a police of good morals, a recruiting center, and a system of tax levy, all ruled by the Sharia, Quranic law was applied to the letter. After reading this dispatch, it could seem that the Sharia is endowed for the journalist and for its partisans with a clear sense and a precise content. Is it the case? What is the situation more specifically? The term Sharia possesses for the believer an intrinsic meaning which it is not my intention to reject or adopt. The sole tenable position consists of observing what is said about the Sharia and give an account of this, indicating in what circumstances and how the Sharia is used. In this respect, we must recognize the multiple understandings of the term through time and space, but also from one person to another, and even more from one context to another. The Sharia becomes a concept which is accessible to understanding only if one studies its practical manifestations, while placing aside the question of whether such a manifestation corresponds to the true or false, orthodox or heterodox meaning of the word. Two examples can help to gauge the variety of understandings of the term. The first is a personal anecdote. In 1992, in Cairo, having had various personal possessions stolen in my home, I took the case to the police. The police pursued their investigations and the thief was caught. I was summoned to the Central Police Station in Cairo and declared that I had identified the thief after the suspect was shown to me. He asked me to intercede in his favor with the police authorities. Once back in the police inspector's office, I said that I did not want to drop the case while specifying that I did not seek vengeance. At that point, the inspector replied directly to me, if we were in an Islamic state and the Sharia was applied, he should have his hand cut off. He is lucky that our civil law is less strict than the religious law. Another place, other customs, another example. In Britain, a storm of protest was caused by the declarations of the Archbishop of Canterbury, who asked in 2008 that some form of recognition be given to the Sharia in the legal system. Radical commentators seized the chance to prophesy that the banner of the Sharia would one day float over Downing Street. Their claims were based on the imaginary figure of 500 conversions each day, with the country destined to have a Muslim majority by the year 2020. At the opposite of the spectrum, one of the organizers of a large demonstration in London around the slogan, "One law for all, not the Sharia," declared that religions are often sources of oppression, but the Sharia is particularly oppressive. However, the Sharia was held to be largely unknowable by most of the scholars of the classical period. The Sharia referred to divine normativity, and claiming to know the Sharia was as good as taking oneself for the equivalent of God. It was shirk. Most scholars preferred at that time to speak of their opinion in this regard. On the other hand, from the mid-20th century onwards, everyone claims to know what the word signifies and how it must be applied. That does not mean that there is general agreement on this signification and how it should be put into practice. Great confusion surrounds the subject of the Sharia. Is it customs linked to countries and societies of Muslim migrant populations? Rules deduced from a body of canonical texts? Law in Muslim majority countries? The political legitimacy of a regime? Or rules of personal and collective ethics? It is not sure that questions such as what is religion, or what is law, or what is the Sharia can be answered. We are not dealing with things in themselves, but uses of words of which certain, not to say many, have a normative signification and are closely related to concepts derived from different languages, cultures, institutions, contexts, and activities. Words and concepts have in common not so much definitions as analogous usages, which one might describe as a grammar. Religion and law do not belong to a physical world, whose terms correspond to external realities. They belong to a conceptual world, and as such acquire their meaning in the context of their use. This is true of the term Islamic law as well as that of Sharia. Every attempt to define academically the concept of Islamic law creates more than it resolves an enigma. Instead of having a correcting attitude, which would lead to state in which sense these definitions are right or wrong, I propose to look at the practical uses of the words, to the ways in which people speak of them, to the nuances they introduce in their languages, to the specific moments they refer to this or that concept, and to what they practically achieve by so doing. The grammar, that is to say the ordering of terms such as Islamic law and Sharia, must be examined in their context of use. Words do not possess an essential but only a contextual meaning, once again. The meaning of words is derived from the circumstances of their use. In function of these circumstances, Islamic law and Sharia can be the reference to Islam in a legal context, but also a slogan which denounces the illegitimacy of a political regime, a concept identified with Islamic normativity before the 19th century, a symbol of the backwardness of Muslim societies, or a term of constitutional vocabulary. There is one thing one can state with certitude. The Sharia is an Arabic word which means or alludes to divine teaching. It is therefore the divine normativity. It is a normative concept on which across time and space a variety of contrasting meanings have been conferred. In this sense, it is a form more than a content. The inheritor today of previous practices and the matrix for the new practices of tomorrow. Rather than claiming that the Sharia is something, one can try to demonstrate what one makes it be. The most frequent attitude towards the Sharia is what one could call essentialist. This is the case of numerous scholarly works giving the term Sharia a precise signification, which it is claimed would keep on governing Muslim people's daily behavior. This conception of things, which likes to believe that Muslims are genetically determined by in their relationship to the Sharia, is unsurprising when it emanates from a dogmatic discourse of, for example, Muslim scholars, ulama. But it is untenable in the universe of human and social sciences, which ought never to accept historical and religious determinism, and therefore the idea that human beings are conditioned by their religious law. Theories of incorporation, embodiment, make Muslims the instruments of this law, whereas a practice-based approach should maintain that the authority and the influence of the Sharia must be understood, once again, as I said, in context, studying who and what was involved and in what circumstances. Rules and conducts cannot be dealt with separately. The Sharia regulation is not, as these authors depict it. It is neither independent of practice, nor does it possess a predetermined clear sense. Neither does it determine behavior in a univocal way. Religious norms, like other norms, are a practical construction, and their authority derives from the power that humans attribute to them. The term of the Sharia is polysemous. It is an amalgam which captures the imagination of journalists and politicians as well as researchers, and leads them to confuse law founded on the Quran and the prophetic tradition, the norms of fiqh, the codified law of Muslim states, and the customary law of Muslim communities. From this, here results a form of certitude about the content of the Sharia, which in turn raises simple norms to a divine status, with the aim of countering what is seen as the secular form of other dispositions. If it is difficult to know what the term Sharia means precisely, one realizes that it is accompanied by affective, moral, and normative associations, positive or negative. The upheavals affecting numerous Arab countries during the year 2011 have put the question of the Sharia back on the agenda. Whether in Libya, Egypt, or Tunisia, to take only these three countries, the Sharia has been invoked by some or used as a bogey by others. In all these situations, a common feature emerges. The term is seen as self-evident, and its meaning is never questioned. Because it is seen as evident, it is used as a resource for the construction of discourses of Islamophilia or Islamophobia, apologetics or denunciations, authenticity or alienation. In fact, Sharia ends up connoting many things while denoting none. It is also true of a multitude of terms imported from a foreign language or poorly, loosely translated, and which have sometimes entered the dictionary. Fatwa, qadi, mullah, mufti, ulama, imam, jihad, ayatollah, and so on. Whether in the language of origin or in translation, there are words which say more than the definition which the dictionary gives them. They transport, they convey modes of thought which often function in order to repeat certain representations of the world. The connotative effect of the words of the Sharia is not limited to its Western usages, far from it. One should underline that the Sharia has become an ideological term before being legal, religious, ethical, or deontological. Sharia marks out the political space, demarcates the factions which struggle for the exercise of power, polarizes societies and the ways that they identify themselves in the eyes of the rest of the world. This is not based on content, but on a mechanism of reference which imposes itself. Beyond the processes of glorification and diabolizing, the content of the reference is evanescent. It is alternately the ideal character of the city governed by Islam or the symbol of its backwardness which is underlined. Often, therefore, the divine law is defined less by a stable content than as the reflection of a political attitude and a way of being, which consists of saying and doing as others in certain domains. Referring to the Sharia is therefore a type of conformism, one all the more solid because it refers to the divine prescription which it is difficult to criticize lightly. Reference to the Sharia divides the world in two, between the respectable and the others. This is a politically productive distinction since it contributes to legitimize or delegitimize actors. In addition, in a Muslim context, the Sharia enjoys credibility and acceptance, and not for merely political reasons. It is part of everyday life. What one understands by the term Sharia is certainly not identical from one person to another, from one corner of the world to another, but it is nevertheless true that in Muslim settings at least, the Sharia is a respectable reference that anyone can appropriate. Using the Sharia in politics is therefore often natural and effective. But rather than struggling to define the essence of things, it seems important to seek what they mean when they are invoked. That does not tell us what the thing itself is, but what people associate with the thing. This methodologically agnostic posture enables us, instead of imposing a transcendental and intangible truth, to understand human phenomena. With regards to the Sharia, everyone seems constantly obsessed by the wisp of its definition. It is true of those who make a foil of the Sharia as well as the guardian of the law who claim to know the norm in its timeless truth. However, if one looks closer, the Sharia is often nothing other than a virtuous abstraction. That is to say, a slogan with positive moral connotations. What Muslims need, everything that is good for them, the Islamic conception of the good, etc. It matters little in a certain sense what that means in practical terms. But the Sharia is no longer understood here as a collection of specific and precisely constraining rules, but an identity-related reference embodying the virtue of the Islamic way. In non-Muslim countries, those who want to identify with this virtuous abstraction will often privilege certain sectors of ordinary life on which they concentrate their ethical militancy. These domains are those of ritual, finance, family, and social relations. They have only a tenuous connection with the positive law. The question of sexual relations outside marriage, for example, receives massive attention by the supporters of an application of the Sharia, while legal reflection has broadly disengaged from the question. Islamic finance is perceived as the means of respecting the Quranic interdiction of usury, but the organization of Islamic finance consists of an offer of banking products whose legality does not have its origins in religious considerations. The respect of certain dietary interdictions or rules relating to the slaughter of animals is a matter only for believers, not legislators. From the moment that public regulations in the domain of hygiene are respected, positive law in these states is completely indifferent to relations between religious confessions, apart from condemning discriminatory practices which go against the principle of equality. These areas of the Sharia belong to morality rather than to law nowadays. It is an order or even a disciplinary obsession. It involves regulating one's life as a believer according to the precepts of a revealed norm. It does not concern those who could be described as sociological Muslims, for whom Islam is more about an ancestry, a familiarity, and a sociability. The Sharia, thus understood, concerns practicing Muslims who aspire to orthopraxis, that is to say, conformity between their daily practices and religious norms. We are in the domain where the individual will of believers guarantees the execution of actions which they see as obligatory, recommended, blameworthy, or forbidden. The call for the Sharia has often become an identity-related demand, a rallying point for those who live in a sort of pluralism where majority and minority cultures coexist and who construct the object Sharia as a point of convergence for everything that might seem to constitute their being in society: marriage, circumcision, burial, festival, Ramadan, diet, and so on. We are not here in the scenario of orthopraxis because people's relation to religious laws is more flexible, occasional, and cultural. The Sharia constitutes a general norm which provides a framework for the organization of these events in a more or less vague fashion. It is not known whether or not these events derive from Islamic prescriptions or local customs. One encounters again the idea of virtuous abstraction, except that this conception of the Sharia does not involve only practicing and convinced believers, but also these sociological Muslims who may not believe and however wish to observe a certain number of precepts traditionally associated with Islam. The Islamist phenomenon, that is to say the political conception and use of Islam, has in large part been developed in opposition to Western countries, with the aim either of making them the entire model of the ideal Islamic city, or to make them the embodiment of the impiety which has to be fought. That does not mean for all that certain aspects of modernity are not appropriated, openly or otherwise, by movements who have contrasting appreciations of the balance that should be achieved between the objective constituted by the Islamic society and the means to attain it. Moreover, Islamism, in all its elements, has taken root as a means of transcending ethnic divisions. The organization representing Muslim communities in France or elsewhere often reflect the dominant political or national influences. As soon as Islamism is involved, the reference to the Sharia becomes ubiquitous. But in countries where Muslims are a majority as well as those where they are a minority, the Sharia is a discursive repertory more than it is a body of determined regulations. In a radical version, the Sharia for movement in all its various manifestations, Sharia for Europe, Sharia for UK, Sharia for Belgium, does not propose more than what is formulated in the name of the organization. A mere call for the application of the Sharia in Europe, in the United Kingdom, in Belgium, and so on, whatever it is supposed to mean. It is tempting to place in the same category the various caricatured conceptions of the Sharia which the extremes of the Western political spectrum sustain. These extremes share a literalist and also reductionist vision of the Sharia, conceived as a collection of restrictive prescriptions in family matters like polygamy, repudiation, husband's authority, or in penal questions like corporal punishments, and in political affairs like the installation of the caliphate. This identical vision is at the same time morally polarized between the Sharia seen as representing virtue and the Sharia as object of criticism. The example of the Lille marriage affair in France constitutes this Lille marriage affair in France constitutes a good example of the double nature of this polarized conception of the Sharia. On the one hand, a man, in the name of the idea that he has of the Sharia, considers that the virginity of his wife, of the wife he marries, is a substantial condition of his marriage. On the other, public opinion, whipped up by the media, imputing to the Sharia a dictate of discrimination which is unacceptable in French society. In law, the question is not problematic. It is perfectly admissible for persons contracting a marriage to insist on substantial conditions which, if not respected, cause the annulment of the marriage. It was indeed the solution adopted by the judge of the court of first instance. In politics, on the other hand, it is more complicated. Once the spectre of the application of the Sharia in France has been evoked, it became difficult not to act, even when it is legally unjustifiable. And this is why the Attorney General instructed the prosecutor to lodge an appeal. In all of this, the Sharia is not very present as a collection of substantial rules, and is even sometimes completely absent. However, the Sharia as a positive or negative moral reference is central. After having been constructed as Islamic law, then removed more or less completely from the law of Muslim countries, it is now inscribed durably in the moral horizon of populations linked in one way or another to Islam. More than ever, it seems that what the Sharia is matters little. What counts is what one makes of the Sharia. Almost all these configurations are imaginable. All these tell us more about those who designed these configurations and those to whom they are attributed than they do about the Sharia itself. Like reflections in a mirror, the Sharia slips away, escapes, returns, but never lets itself be caught. This is the same trend one can observe in scholarly attempts at making the Sharia an object of scientific investigation. The term Sharia has been the object of multiple studies which seek to delineate its meaning. These researches, through a particular methodology and within a particular discipline, seek to define what the word Sharia is and to what it refers, setting out what the word denotes. For the most part, these researches concern its etymological, dogmatic, and historical meaning. However, there exists a cultural lock in the study of the Sharia. This is due to a double attitude. On the one hand, there are inaccurate extrapolations based on specific knowledge. That is to say, a tendency to consider that knowledge of one aspect of Islamic culture allows one to comment in general on everything Islamic. Those competent in medieval Muslim theology are consulted, for example, in order to advance explanations of contemporary Islamic political radicalism. Claims are also made that a style of political thought, rooted in the writings of classical authors, that of the power of obedience, has perpetuated itself from the Middle Ages until now. There is an attitude of omniscience with regard to the present day based on particularism of culture and history. Thus, it would be improper to speak of state in a Muslim setting, because this term, whose etymology refers to the idea of institution instability, does not reflect the intrinsically unstable nature of power in Islam, reflected in the word dawla, whose etymology refers to the idea of cycles and instability. Such an attitude is an aporia, a deadlock, because it implies that elements of languages and cultures are impermeable to translation. All these explanations, be they etymological, dogmatic, or historical, impose a similar conception on us, a conception simultaneously learned and simplistic, of what the Sharia is, and above all, of what it does to people. Sometimes the discourse is apologetic, sometimes critical, or even derogatory. The question must not be approached in this way if we recognize, as Muslim specialists in jurisprudence did, that the designs of God are not accessible to human understanding, and that in consequence, we can only describe what humans have made of a word were it divine. All this being said, if I had nevertheless to summarize the Sharia in a few words, I would say the following. Yes, the Sharia is firstly an Arabic word which does not have its own clear, obvious and universal meaning. Only the terms used across space and time can convey to us what the Sharia is. In other words, the term does not have an intrinsic meaning accessible to, at any rate, human understanding. Grasping the meaning of the Sharia means imperatively discussing it in context. It is the perspective of the nascent Shafi'ite school in 9th century Baghdad, or that of Jalal ad-Din Rumi in 13th century Konya. Is it the context of the Ottoman Empire at the reformist Tanzimat period in the 19th century, a period that can roughly be compared to the Meiji era in Japan? Or is it the Egyptian context of the Muslim Brotherhood government after the 2011 upheaval? Is it a question of doctrinal production, judicial practice, or political demands? The term Sharia derives its meaning only from the ways it is used. What is said and understood of the Sharia can therefore only be understood in present context and not in ethereal, weightless terms. When one begins to study the Sharia as a term, it should be discussed as a language game. One notices that the term can sometimes assume a legal sense, as is the case of the word, the expression Islamic law, sometimes in a political sense, when in an election campaign there are calls for the implementation, the application of the Sharia. Putting these language games in perspective allows us to see the extent to which the term Sharia can function as a rallying point for identity. On the one hand, it is used to promote a specific heritage. On the other hand, it serves as a bogey, as a scarecrow. The traditional viewpoint has been that the Quran and the tradition of the Prophet, the Sunnah, i.e. the narrative of his acts and words, are the two pillars of Islamic law. The Quran is the sacred book revealed by God, as it took definitive form in the 50 years after the death of the Prophet Muhammad. The tradition of the Prophet is the body of sayings and doings of the Prophet, as it accumulated over 2 centuries from the time of the Prophet onwards. Both the Quran and the tradition are only marginally concerned by prescriptions and proscriptions, what is recommended and what is forbidden. The sacred book and the tradition are above all composed of elements of mystical inspiration, moral exhortations, and edifying stories. They reflect the context of the revelation of the Quran to Muhammad, the Arabia of the 6th and 7th centuries, and the life of the Prophet, who transformed himself from preacher to head of an incipient religious community. In addition, these two main sources of the Sharia, in the course of their constitution, as well as after the final fixing, have always depended on the readings proposed by their respective specialists. One can think here in particular of the important tendencies within Islam represented by Shiism and Sunnism, and the four main Sunni schools, Maliki, Hanafi, Shafi'i, and Hanbali. Reference to the Sharia are not frequent in the Quran. In reality, early Muslim scholars did not evoke the Sharia and did not even claim to know it. Writing on Islamic normativity from the 9th century onward assumed the features of a particular form known as fiqh. The best translation one can give of this term is that of doctrine. That is, a set of principles that are taught by the scholars of a particular group. Treatises were produced in each of the great Sunni schools as well as in the Shia family, followed by commentaries and summaries of these treatises. In parallel, the technique of consultation in view of a legal opinion, what is known as a fatwa, became widespread, and collections and compilations of such consultations were often made. One should underline the effect of the emergence of empires, notably the Ottoman Empire, on Islamic normativity, when the Hanafi doctrinal school became official state doctrine. As a result of colonization or the pressure exerted by European powers, numerous countries embarked on a process of reform which led in most cases to the transformation of Islamic normativity into statute law, especially in the domain of the family. Knowledge of Islamic normativity, that is to say jurisprudential doctrine, is one of the main disciplines of scholarly Islam. The science of the foundations of this normative knowledge was developed in order to set out clearly its sources and rationalize its methodology. It is called Ilm Usul al-Fiqh. According to modalities which can vary from one school to another, this science has four foundations: the sacred book, the Quran, the prophetic tradition, the Sunnah, the consensus among Muslims and their scholars, Ijma', and analogical reasoning, Qiyas. The great scholar Muhammad al-Shafi'i, who died in 820, is the leading scholar in the science of the foundations of doctrine. Among other things, he enabled the relations between the first two sources, the Quran and the Sunnah, to be clarified. Treatises of fiqh are always concerned in the first place with ritual obligations associated with Muslim devotion. These are the five pillars of Islam: the profession of faith, ritual prayer, almsgiving, fasting, and pilgrimage. To this are often added requirements of ritual purity and dietary interdictions. Secondly, these treatises are concerned especially with family relations, an area on which Islamic rules concentrate: marriage, divorce, filiation, succession. It is among these family-related rules that one finds numerous prescriptions and proscriptions that are still debated today, such as the rights of guardians over women, the endowment of wives by their husbands, the authority of husbands, and their unilateral rights to dissolve a marriage, the imbalance in the duties of wives and husbands, and unequal inheritance rights determined by gender. One should note that the exercise of justice in the context of medieval and modern Muslim societies was generally separate from the activity of doctrinal production. On the basis of his knowledge of fiqh, the judge had a wide margin of discretion. Often he based his decisions on the results of consultation with an expert, the mufti. What is called Islamic law does not correspond to a reality as ancient as Islam itself. The idea of transforming norms into positive statutory law, and in particular into codified law, is the result of an invention rooted in the European intrusion onto the Muslim scene. Orientalist scholars and colonial administrators, on the one hand, and Muslim rulers and new elites, on the other, sought in fiqh materials susceptible of being poured into the mold of Napoleonic-style law codes. This grafting process was successful, and today the notion of Islamic law is an element of the ordinary and normal horizons of political and legal thought in Muslim-majority societies, as well as societies with a strong Muslim minority. The Sharia, therefore, was codified, especially in the area of family relations, with which it was particularly concerned. The term of personal status, which is used to describe this family-related legislation, is most speaking in itself, as it does not originate in the fiqh language, but in the civil law distinction between real status and personal status. Most countries with a majority Muslim population have a specific family code, which in general is in a highly variable measure is inspired by the precepts of of Islamic normativity. Fiqh continues to exercise an influence in another area, that of the pious foundations. In other domains, such as finance, one can find a religious inspiration. Most often it is a question of contemporary developments on subjects which have only been sketchily treated by fiqh, but for which can be found in the sacred text a disposition which can provide a justification for their regulation. This includes, for example, the Quranic interdiction of usury. A relatively recent phenomenon can also be observed with regard to the constitutions of Muslim majority states, namely the referencing of the Sharia in the constitutions as a source of legislation. It is no longer a case here of codifying Islamic normativity, but of directing the attention of contemporary legislators to this normativity in order to bindingly inspire their lawmaking activities. Today, the Sharia has often become a political slogan. Here we have a Muslim brother during the Mubarak era who was asking for the floor, desperately asking for the floor. It is not so much the case of converting the Sharia into Islamic law as taking a claim to the Sharia in the face of regimes whose authenticity, including their religious authenticity, is contested. However, most of the time, political parties calling for the application of the Sharia do not have a program detailing the content of the Sharia and what should be abrogated and replaced in legal systems. Application of the Sharia is above all a claim of political ethics and the marking out of a reference rather than the application of precise set of rules. Last but not least, the presence of Muslims in countries which are not Muslim majority countries has led to the emergence of numerous questions. Some are legal in nature and concern the recognition of rights inspired by Islamic law in states which are overwhelmingly secular. Others concern the practice of religion and the possibility of living out one's faith in societies where the predominant references are to human rights and the principle of the religious neutrality of the state. Here the question of Islamic normativity is not so much legal as ethical and deontological, that is to say moral. The question is how to live in conformity with one's convictions in societies whose populations may for the most part not share these convictions. Science often makes simple things complicated. I have tried to do just the opposite and to make complicated things as accessible as possible. This book is both a map and a guidebook. I've concentrated tonight, this evening, on the map. You have still the possibility to read the book in order to get access to the guidebook. I'm not sure that I have succeeded in making complicated things as simple as possible, but I can assure you that what I did it to the best of my knowledge and capacities. And I thank you.
Okay, thank you so very much. The floor is open for questions and comments. Let's start in the corner over there. And wait for the microphone before you speak, because we have listeners and participants online as well.
Thank you very much for your very informative and illuminating presentation. My question is about the future of Sharia, and I'm focusing at the moment on Pakistan. Within the area of family law, Sharia law becomes very complicated and very problematic, especially looking at the honor killings and the spike in the number of it, and recent case of an Italian woman killed in Pakistan, as the media, international media has highlighted that recently. What future do you see in Pakistan of Sharia when there is a parallel law internationally and nationally, and international law is by the passage of time basically displacing the local law to periphery? Thank you very much.
Thank you. You want John?
Yeah, no, take this one. Please go
ahead. So of course I'm not able to really speak about the future of the Sharia. What I can say is that your example, about which I know little, as I said to our colleagues, but nevertheless little, is a very good example of what I tried to explain this evening. That is to say that the Sharia is very often more an empty shell than a real content. Honor killings are very often associated to the Sharia. Nevertheless, it is hard to find in fiqh any sentence directly justifying honor killings. Honor killings are customs which are Islamicized one way or another. And to give just a little example, not coming from Pakistan, but from another country, from two other countries, Egypt and Morocco. We have cases of women who were, who were kidnapped and raped by men, and who after a while had to marry this very man who can escape, the penalty when marrying the woman he raped. These provisions are often attributed to the Sharia and to Islam. By the way, in the case of Egypt as well as in the case of Morocco, they are borrowed from French criminal law from the early 20th century.
Yes.
This is not to say that there is no relationship between honor crimes in the Sharia or Islam. Of course not. There is a relationship for the simple reason that people claim it is related to the Sharia. They think it is a proper implementation of the Sharia. But this really shows how much the word Sharia, which is the same everywhere, corresponds to different concepts, which are really contradicting and conflicting with each other. Mm-hmm. I think this example is good in order to tell you that there can be a bright future for the Sharia, but it is not depending on the Sharia itself. It is depending on the people interpreting the Sharia, using the Sharia for practical, legal, moral, political purposes. As long as people are using the Sharia as Ziyal Haq, use the Sharia in Pakistan, while not knowing anything about the Sharia, I can assure you Ziyal Haq was not an alim. I don't know anything about Pakistan, but I know that Ziyal Haq was not an alim. But nevertheless, he used the Sharia for pure, blunt political purposes. And this is still the case as far as I know, and at least in other countries I know better, it is the case. So if the Sharia is used like in Sudan in order to promote an authoritarian regime, of course the Sharia will prove very conservative, oppressive, and anti-human rights and whatsoever. But the Sharia can be used by other people in other directions, and in itself it is open to positive and much more progressive interpretations.
Thank you.
Yeah. I did my PhD on Sayyid Qutb, and in my thesis I argued that he linked Hakimiyya to Sharia. And therefore now you see, for instance, a lot of laws that are not originally coming from the Quran, like liquidation, for instance, is not Quranic. And Saudi Arabia applies 2,000 lashes to opponents. It's not Quranic. And all this is just because in the name of Sharia now they silence all opposition. And therefore there's an argument that ISIS is applying the same law as, there's so much stress on penal code, and therefore Boko Haram or ISIS or Saudi Arabia, they all follow the same law, and they say this is coming from God, and it's not true. The other thing I wanted to say that in Egypt now there are calls to reduce the age of marriage for children to 9 years old, because it's in all the schools of jurisprudence, following in the footsteps of Muhammad, they want the children to be married at the age of 9. So what do you think about this? This is the Salafi movement in Egypt.
Regarding the last question, it might be a claim from the Salafi movement, but the law is nevertheless very clear that the woman, the wife, should be of the age of 18, and exceptions can be granted by courts, but not under the age of 15 in any case. But then the law, official law, law in the books, law in practice, what is done in the society, these are very different things. You're right saying that there is a kind of obsession regarding criminal law, so-called hudud, even though often what is related to hudud is not dogmatically speaking true. As you mentioned, a variety of penalties which do not appear in the Quran. But then you have the accumulation of the fiqh. And the fiqh also drew from the prophetic tradition. And you know that the prophetic tradition is not one univocal body of rules, of prescriptions. I can give you an example from Egypt, since you seem to be Egyptian and familiar with Egypt. It is about female circumcision, khitan. It is the case, of a ministerial decree forbidding the practice of female circumcision in public hospitals and by public doctors. Then a group, a collective of Islamist lawyers filed a suit against the decree of the minister, saying that it was running against a prophetic tradition, not only allowing, but encouraging and making female circumcision compulsory. Then the court entered into the game, and it said, on the one hand, yes, we have Article 2 of the Egyptian Constitution saying that the principles of the Islamic Sharia are the main source of legislation. So if female circumcision is a real principle of the Islamic Sharia, it should be applied and obeyed. But on the other hand, it is about this specific tradition concerning female circumcision. And this tradition is absolutely not univocal, consensual. There are many other traditions directly contradicting this specific tradition used by these lawyers in order to protest against the ministerial decree. So you see how the same body of rules can be used in conflicting terms. And nobody really agrees on the question of female circumcision, but also flogging, also what are the conditions for adultery, what are the conditions for defamatory accusation of adultery, and so on and so forth. This is a domain of contentious statements, conflicting each other and used by different parties in order to promote their stance. But these stances are definitely not shared by all Muslims. I don't know whether it is a proper answer to your question.
I'm just not clear about the 2,000 lashes. Where do the Saudis get the authority to, apply this? Where does it come from?
You have first, the Hanbali interpretation of the scriptures, the Hanbali Wahhabi interpretation of the scriptures. And this is not always strictly sticking to what is stipulated in the Quran. You can have also the prophetic tradition allowing, or one prophetic tradition, possibly contradicted by another prophetic tradition, but establishing the amount of lashes to a certain number. Yeah.
So you talked about Sharia and how it is being traced in different countries. So do you think that in future, when we talk about the form of Sharia law, will it influence the state law of any country, like the way Sharia law influences the state law of Pakistan? Do we see some traces in the other developing countries as well? And is there a possibility that someday the state law may influence the Sharia law as well?
My answer to your last comment, it is not only a future possibility, it is a very present reality.
Yeah.
The Sharia is totally transformed by legal thinking. This is my point precisely. Sharia was transformed into Islamic law. Islamic law is not the proper translation for Sharia. Islamic law is Sharia as thought about through the Western positivist legal cognition, legal way of thinking. So yes, definitely, what we call Sharia today, especially Sharia law or Islamic law, is totally, thoroughly influenced by the state and state law. That's definitely. Then the future is open. What I can tell you is that what happened in Egypt is not what happened in Pakistan. In Egypt, via Article 2 of the Constitution and the Supreme Constitutional Court, there was a distinction made by the court between the absolute principles of the Sharia and the relative principles of the Sharia. Those fluent in Arabic, الأحكام قطعية الثبوت والدلالة والأحكام الظنية. Between these absolute principles and these relative principles, there is a huge gap. If there is an absolute principle, the legislature is bound to follow these principles when legislating. But with regard to relative principles, the legislature is not bound by these principles and can decide, providing it follows, it searches, it seeks the interest of Islam and the population. But up to now, the Supreme Constitutional Court never identified an absolute principle of the Sharia which had been violated by the legislature, meaning that the Sharia is incorporated formally, but had never the same consequences it had in Pakistan via Ziaul Haq legislation.
Yes, yeah. That's, there is there that you and I think there are a new. So 5.
5 years.
I'm going to invite you all to for a little bit of food afterwards. So if you're going to follow up question, I think we'll have that over whatever food we are serving. I'm not sure about that. Because I think there are so many. So please keep the questions reasonably short and the answers reasonably.
It's just a congratulation. It's a wonderful book. I read it last night. It's wonderfully written. I have been teaching Sharia law for the last 25 years. having read many of the authors, I think this is the best production on Sharia law, very precise, concise, and readable for the students of Sharia law. With regard to the sources, as the lady was saying about honor killing and the circumcision, honor killing has as much to do with Islam and scriptural sources as much as circumcision is, which is none. Which means honor killing has nothing to do with Islam, circumcision has nothing to do with scriptural sources. And Sharia is being used by all these people, especially in Arab countries, as something to make things vague. When they say it is according to Sharia, so it means when they can decide whatever it comes into their mind and say, well, this is Sharia and that's how they want to implement this particular law. But the point is, and that's why in Pakistan and in South Asian country, whenever Sharia is talked, it's talked in sense of Quran and Sunnah. In Pakistani constitution, you will not see a reference to Sharia. The reference is with regard to Quran and Sunnah rather than to Sharia. But in Arab countries in constitution, the reference is to Sharia to make things more vague. My question is, having taught and read, and having understood that it's Shafi'i who is the architect of Sharia, when was the first time in Arab world the word Sharia was used as a legal norm rather than a course to get a legal norm, but as a legal norm, as being misused and abused by ISIS and by ISIS-like Taliban and other people? So when was it that first time in the Middle East or in Arab, Sharia was used not as a source, but as a legal norm to implement, if you could have?
This is a very important question, and I think there is an answer. I'm not sure I know the answer, but I think this is a type of question which has an answer. Personally, I would look for the answer in the legal life of Egypt, starting from the early 19th century until As-Sanhuri, codification of civil law. I think through this process, this is not that Sanhuri was the first, but through this process, and there is an excellent book by Leonard Wood on Islamic revival, legal revivalism. If looking into the details of this process and this transformation of fiqh into a positive statutory law and positive law and positive legal thinking, I think we could find the guy who first invented the modern way of speaking of the Sharia. I'm not sure about Abu Zahra, perhaps. It might be the case, but I'm not sure. It is really.
That's an important question. I think that's
but there is a journal, an Egyptian journal, there is Majalla al-Qada al-Shari'iyya, and there is also coming from the Sharia faculty in Cairo University, an important journal who's already using the word Sharia in order to refer to Islamic law, which is the witness of the transformation. But who's the first? I don't have an answer.
Thank you.
No, Sayyid is afterwards.
Oh, it's much later.
It's not the first one. Definitely not. The Hakimiyya is a good question. That's for sure. The Hakimiyya, sovereignty, like Wilayat al-Faqih in Iran. It is really a modern understanding of all the references. And this is illustrating the way former sources were reshuffled, transformed, re-understood in very different terms.
Thank you for your lecture. My question is about, you have said that Sharia is a form and the content is provided by different time periods and perspectives and contexts. So is there anything common to these forms, maybe some core constituents that make this form that is common across the time period? And if not, then what are the absolute principles that we're talking about? Are these absolute principles also relative to the time period? And in a sense that there are no absolute principle in Sharia, then this is all relative to the time period and context. Thank you.
Absolute principles in the Sharia, there are few, even though my what I'm saying can be, of course, very contentious. Just to give an example, ijma', which is known as a major source of the Sharia, of fiqh at least. It's one of the usul al-fiqh, the third one. Even an author like Ibn Taymiyyah, who tried to define what is the product of consensus according to Islam, was able only to write about something like 15 pages regarding what is consensual in Islam. And it was mainly about Tawheed, the uniqueness of God. Only these principles, like Muhammad as the messenger of God. Yes, these are principles which are really at the core of Islam and are consensual. Not claiming, not claiming the uniqueness of God or Muhammad as the messenger of God, be making a kind of logical mistake, because logically speaking, Islam is about uniqueness of God and Muhammad as a messenger of God. But beyond these very broad principles, so few things are really consensual.
Yes.
I think the same holds true with regard to the Sharia.
Yeah.
The Sharia is the path to God.
Absolutely.
But nobody is telling you in the Quran what are precisely the provisions of this very path leading to God. This is only fiqh, which is opinion about the Sharia that progressively, in a accumulating way, produce answers to these questions.
Absolutely.
So there are consensual answers in fiqh. You will find among the many madahib, the many schools, you will find common solutions. Not always, by the way, very often not consensual, but you can find also consensual answers. But this is fiqh. This is not the Sharia. The Sharia itself, the word Sharia in the Quran, how many times does it occur?
2, 3, directly.
And Shar.
No, that's
Sharia.
One was Ja'alnaka Sharia that you just was there. That's I think the most direct one. But otherwise 2 times,
So
altogether 3.
you see how much it is about historical accumulation after. This being said, the content remains evanescent.
Would you agree that the rich range of definitions and concepts that you have introduced about the different aspects of looking at Sharia would encourage studies from other perspectives? I would like to cite 3 examples. Analysis of discourse, of media, motivation, and messages. Example is Sharia issues discussed by Fox News Channel and by Al Jazeera. And then for political scientists, the use of Sharia as a banner for protestation and protection or escape route. So there are 3 manifestations that people pursue using their own interpretation of Sharia. And lastly, study of social attitudes, where people use Sharia as a shield, as a cover, as a deflection, or as a hold-all for ambiguity. So I don't want to follow some rules and I say, I escape, I take the flight path out because I adhere to Sharia, saying I do not recognize your rule. So this is my escape route rather than my ideology. So would you agree?
Yeah, fully. I don't know. I don't know how much my talk was clear. I try to do it, but really these are among the major points I wanted to make. You know, the Sharia is for all practical purposes. The Sharia is contextual. So if we are embedded in a context, in a media context, and this context has very practical purposes, you know, communication, convincing people, sharing ideas, ideally, I'm not sure media are so much about sharing ideas, but, and so on. Yes, the form the Sharia will take is totally constrained by the context in which it is used. The same holds true with regard to the Sharia as a scapegoat. You know, nowadays, of course, the problem with ISIS is very thorny and sensitive because it gave, from within the Muslim community, it gave an idea of the Sharia which is totally caricatural. It is, you know, and it is reflecting the ideas Islamophobic people have in the West, in Western media or in rightist movements and so on. You know, the best ally of Marine Le Pen in France is most probably the Islamic State. They have the same conception of Islamic criminal law: hands cut off, heads, lapidation, adultery, Mahmoud Mohammed Taha, and so on. This is the way, you know, the apostasy, and they have the same conception, not of course with the same intent. On the one hand, it is supposed to be the right interpretation of the Sharia for all good Islamic purposes. On the other hand, it is the example, the paramount example of what Islam is and the reason why we should exclude Islam from everything. But at the end, they share the same idea, which is definitely not the idea we can have when reading other sources. So yes, 100%.
I feel I must go back to the point this lady made, because there's so much publicity, either rightly or wrongly, concerning the issue that she raised. And she mentioned lashing and circumcision, female circumcision was mentioned, and you showed a chart of depicting sex slavery and necrophilia and so on. And of course I defer to you because of your knowledge, and the gentleman who's been teaching for 25 years. What he said was that issues like female circumcision and honour killings and so on have no place, or there's no reference in scripture, Islamic scripture. You said that there were conflicting traditions. Now, are you saying that these terms are mentioned, for example, in the Sunnah of the Prophet? What do you mean by traditions? Or are you saying that? I'm just trying to find out if these terms, honour killing, female circumcision, lashes, are actually mentioned, in fact, in scripture, Islamic scripture, no matter what form that takes. I think that's what I'd like to know.
So it depends on one question, on the question.
Rather than relative interpretation.
But in the case of female circumcision, you can find hadith da'if, you know, prescribing female circumcision. But this is, you know, then there is another thing to address. What is ilm al-hadith, the science of traditions? It organized traditions in many categories according to the way they were reported, to the way, to the quality of the reporters, to the substance also sometimes of what is reported. In the case of female circumcision in Egypt, there was in the file, in the suit case filed by the lawyers, there was a tradition, a hadith mentioned by the petitioners. So and this is where, of course, scriptures are not consensual, and especially the Sunnah, but also the Quran. You know, it is only through a specific theory of nasikh wa mansukh, abrogating and abrogated, that conflicting verses have a univocal meaning nowadays. Take the example of drinking alcohol. You have one verse, making it compulsory, at the time of the prayer, not to drink alcohol, and then you have a later verse making it generally compulsory. But there is no verse in the Quran saying that one verse was abrogated by the other. So there is on this theory of later verses are abrogating for earlier verses.
Anything in Sunnah about abrogation?
Yes, of course. And Shafi is the main conceptor of the theory of abrogation. Also the relationship between the Sunnah and the Quran. Can the Sunnah abrogate the Quran? Of course not, because the Quran is the word of God. But eventually, Shafi says that only the Sunnah can abrogate the Sunnah, and only the Quran can abrogate the Quran, and they cannot cross-abrogate each other. But this is human interpretation, of course. Good interpretation, clever interpretation, in the sense of very clever interpretation. But you can find sources. You can find things in the scriptures. Good things, that's another issue.
Thank you very much. I'm interested to ask a question about the governmentality of the Sharia. And I think if we think about the governmentality of the Sharia, or at least using Foucault's discourse of governmentality itself, there's a very strong influence that the Sharia has on individuals as well as on populations. And I think if we compare it, the director will agree with me somehow that strong states have a very strong control over, not control, but influence over the populations. And an example would be Scandinavian countries, where the population really very little rebel against the state, rather they do everything to strengthen the state. I'm not saying that everybody's happy, but compared to the rest of Europe. So with the Sharia, I see in a similar way, whether people are by their heart happy or not happy, they pretend to do everything to support this governmentality of the Sharia. However, if you compare it with some strong states like Scandinavian, I would see rather in the present day use of Sharia a more dictatorial influence rather than the way Scandinavian states and citizens would do. Now, having said that, my question, rather that as I was also interested on the unspoken parts of your book, that is the guide. So how would you think that if you want to unburden the Sharia from all these multiple rationalities that are often, we all know, for the sake of political, personal, and many other interests, that how to unburden them and perhaps make it in a way that this governmentality of the Sharia would come more like as a free will, like as the way a good citizen in a liberal state would do, instead of really like a stick and something like that. And as one specific example for that would be this Liverpool football player, Mohamed Salah. Now he has a dilemma whether to fast in the final Champions League or not, and why his faith and honesty to the Sharia and to Islam should be in the hand of the Mufti of Egypt. When he says you can break your fast and you can eat and then do it later, if everything is okay, suddenly for him, and if not, it's not okay. So why people, the question is here that how to unburden this entire phenomenon, that these multiple interpretations and rationalities are claimed to be as good, as authentic, as original as the Quran itself. So that's my point of view. Thank you.
Of course, I can't really answer your question. What I can tell you is my heart. You know, I think that positive future for the Sharia is to make it as little legal and political as possible, and as much moral and ethical as possible.
Yes.
If we exclude from the realm of the Sharia the legal, the strictly legal, so making compulsory, and the strictly political, you know, contesting the rule of somebody else in the name of God, I think a big step would have been made.
That's the next step of transformation of the Sharia.
But the real predicament of the Sharia is probably nowadays its legal transformation. Its transformation into the law of states. So its association to both the state and to state law. And that's really made it impossible to use it in a progressive way, to escape from the authoritarian rule of people not very well intentioned.
Thank you. Okay. Now one more question, and that will be from an online participant.
There is a question. Could you please give an example of where Sharia is viewed positively from a Western viewpoint?
I really think, this is not a good answer, but if we take Mahmoud Muhammad Taha, and the way he addressed the issue of the Quran, I don't claim that he's right, he was right or not, but I think it was a positive way to think about the problem and to try to find a solution. There are ways open to our minds, and it is one among many. So let's take the Sharia for its mythical, mystical dimension, and let's put the mu'amalat, or at least the legal side of the mu'amalat aside, in order to concentrate on the most mystical aspects of the divine teaching. This is one path among many, but a path which I think is quite positive, not totally negative.
Taha is wonderful. Second message of Islam.
Okay.
But there are many people who claim to be Muslims, but who don't abide by this legal positivization of the Sharia.
Okay. Discussions can continue, of course, but you're all warmly welcome to share with the food. But first, before we go out, I think we should warmly thank Professor.